compensate for land and improvement for indigenous Zimbabweans who constitute only 1.3% of the 18,600 farmers that were allocated. We have also an obligation under the Constitution to consider the bilateral investment protection and promotion agreement and bilateral investment treaties. And those constitute just under 1% of the 18,600 beneficiaries. So those fall in the category that the SI 62 of 2020 clearly explains the procedure for that. An application is lodged with the minister. There is consideration whether in the public interest, defense, security for the country, there is merit in doing so. Where it is no longer possible, then compensation is offered. So for me, that's very clear. Then there is the category of former owners. And we are saying those who do not have regularized documents should immediately approach the relevant government institutions, offices scattered around the country so that they can lodge their application. That's indicating that the land reform program is irreversible. So those that are there ought to follow the law because the land is vested in the state. And that category of farmers is 294. And again, about 1% of the 18,600. So altogether, the numbers that we are looking at, addressing, redressing, for the clarity that we gave the day before yesterday, affects a mere 3.2% of the beneficiaries. So as we do these processes, many of you will actually never notice it because it's such a very minute proportion of the beneficiaries. So that's the clarity that we are couching to ensure that in vernacular, everyone understands that the position of government is that the land reform program is reversible and that the global compensation deed clearly articulates that, and there's acceptance by both parties that we now need to move to a second stage, which is ensuring that we increase agricultural productivity, we increase production, and we increase profitability so that agriculture becomes a business, so that this country moves its way up into food security territory now into the future. So that's the clarification. Thank you very much.
Would you want to interpret the question?
One or two questions?
Yeah, two questions.
My name is Ishmael. My question, Minister, is about the agreement. I think more than 90% of former white commercial farmers agree. They voted for it. What happens to the balance, the 5%?
95%.
Also, what happens to their title deed? All of them.
The land is vested in the state. So that clarifies the title deed. The 5%, perhaps you could ask them what they wish to do. They are 95% of their membership have agreed. You can go to CIFU and say, so what is the balance of your membership going to do? The government is genuine and has done the best under the circumstances to honor the provisions of the Constitution, which we overwhelmingly adopted in 2018.
Okay, a lady this time.
Yeah.
No question.
Yeah, I'm a lady.
In case
In case you didn't notice. I mean, there's been a lot of jitters amongst people in response to that statement that you have made. What guarantees can you as government give Zimbabweans that you won't change this global compensation agreement and return the land in the future?
The guarantee is vested in the Constitution. The Constitution is very clear about the procedure, and we're just following the law.
Next question. Another lady? Okay.
My question is particularly on the global agreement itself in terms of the 3.5 that is supposed to be raised. There's been some concerns that have been raised that the 3.5%, are you not asking now the taxpayer to fundraise this 3.5 when you have individuals who benefited from the land reform who are sitting on those funds and enjoying the improvements that are supposed to be paid? And then also secondly, what act of parliament are you using for this process? Because the Constitution itself says there's supposed to be an act of parliament for this process to happen.
I'm not aware that the Constitution says so. You can favor me with the section that says we need an act of parliament. But
Yeah, it's under section 70.
as you know, all the land processes have been done legally, and parliament has the oversight, and when money is appropriated for specific uses, it is done and goes through parliament for approval. So that institutionally all the legal processes will be followed. And your first aspect related to
the 3.5.
How it is going to be raised. That colleague, Minister Professor Mtuli, Finance and Economic Development, will be able to articulate in future.
Thank you. Minister, reading the statement that you issued, I think the worry is that when that statement says government is going then to revoke permits from farmers who were relocated to give to the former owners that piece of land. The problem there is people feel that you are reversing the process or the land reform program as it were. And what is going to happen to these people? You say in a statement that you are going to relocate them somewhere. The challenge is, as a country, are we not going in a vicious circle where people who were relocated on pieces of land in 2000 are now going to be moved after having developed parts of that piece of land? What is also going to happen to them in terms of compensation? Is this government going to compensate them for the developments at least?
The apprehension is uncalled for and unnecessary. SI 62 clearly states that an application is made to the minister, and the minister considers the specific circumstance for that particular holding. And if there is consideration that there will be little or no disruption, then the minister may then allow that indigenous owner, that people to come back. And it clearly states the categories that the minister has to consider and the preemptive steps before consideration can be made. So in my view, there will be very little or no disruption in this process because the numbers we are talking about are minute. So a reassurance again that this statement is about clarification of the global compensation deed of 29 July, and that this is not reversing the land reform program. The land was the prime cause for the first and second Chimurenga and for the fast track land reform program that we undertook, but we acknowledge that in the process there were few properties, and as I say, 2% that were in that process included in this, and now we want to follow the law in terms of the Constitution to correct that aspect. So the apprehension at this stage is unnecessary. So please, your reportage ought to be as objective as is humanly possible, so that this apprehension is eliminated and people go about their lives on the farms and they focus on production, productivity, to ensure that our country becomes food secure and food secure from this season going forward. Thank you very much.